Let me ask you a simple question. What would happen to everything that you own, meaning your money, your home, even your kids, if something were to happen to you tomorrow and you weren't around? Most people assume that everything will automatically go to their spouse or their kids. And in some cases, that might eventually happen, but not without potential delays, court involvement, and even cost to your family that they're most likely not expecting. The reality is if you don't have the proper documents in place, accounts aren't structured correctly with the right beneficiaries, your family could be forced into a multitude of scenarios that's just going to create chaos for them rather than for something to be smooth, especially at a time when there's a crisis going on. The reason I'm talking about this today is that, as you know, I'm a financial advisor. I've been doing this for 16 plus years, working with people on ways to basically grow their wealth, but also how to protect it. And so in our daily conversations that we have with clients, when we get to the estate planning portion, the common things that we typically will hear are that, hey, we're not wealthy, we don't have a tremendous amount of net worth, we don't really need that yet. Or we've been meaning to get to it, we just haven't, it just hasn't been the right time. Or I think I did something years ago, let me see if I could dig it up. There's so many other things that we do here, but that's really the goal of this channel. Taking the things that people actually say to us as advisors, the assumptions and the blind spots that people have but almost don't know they have, and really walking you through where the real risks are. Not only can this happen to you, but there's also plenty of cases where this happens to very well-known people out there, famous people, celebrities, athletes. You can go look up what happened to Prince and his estate. You can go look up and see what happened to James Gandolfini and his estate and the problems that it ultimately created for their family and loved ones. Because at the end of the day, when we're helping our clients with their financial plan, yes, you want to grow your wealth, but it isn't always about that. It's also about protecting it, directing it, and making sure that it serves the people that you care the most about. So in today's video, we're going to break it down. What estate planning really is, the documents that as a non-negotiable you should have in place, and that goes for whether or not you're 35 or 65. So with all that being said, let's get into it. Okay, so let's talk about what estate planning looks like. Now, if you sit down with any good trust and estate attorney, of course, one that we would refer you to, they'll usually draft a core set of documents that are, as I was saying in the opening, are non-negotiable. You really need to have. These are part of the tools that are going to help your family either have clarity or chaos in a moment of crisis. So here's what's included in a basic, fundamental estate plan anytime you're going to sit down with a good trust and estate attorney. And we'll go through why it even matters. So the document that most people have heard of the most is the will. And I think what I hear a lot of times is when people do hear estate planning, that's what they refer to. They don't understand that there's other documents that are involved and other ways that you can make sure that your family has clarity. It allows you to spell out who gets what when you die. But even more importantly, it's going to even name who's in charge of settling your estate. And this person is called your executor. And if you have young kids, we don't even necessarily care about where specific assets are going to be going. What we care about is naming a guardian for your children in case something were to happen to both you and your spouse. Because if that situation did happen without a will and without guardian's name, the court could come in and really decide where your kid should go. Also, another important component of a will, and you're going to see this as I go through the video, a will doesn't necessarily enable you to avoid probate altogether. And we'll touch upon what probate is in a little bit. A will simply gives the probate court instructions on how to proceed. Everything still has to go through the court system no matter what. It's just what we can bypass as a function of that. And again, we're going to get into that. So if your plan is just to have everything go to your spouse, that might seem pretty simple. But without a will, the state can come in and basically just divide things differently than maybe how you would want them to be directed. And this is especially true if you have children. Now, I'm not saying that's always the case, but it can happen. The other document that you're going to want to have in place as well is going to be a power of attorney. This is pretty simple. This just gives somebody the legal authority to handle your financial affairs while you're still alive, but you're unable to act upon anything. So an example of this could be paying your mortgage, paying any sort of bills, things like that. And the reason that this is important, because without this particular document, your family might have to go to court just to access your accounts or even your bills. Now, again, this is going to go back into how do you structure and title accounts and things like that. But that is important to have an understanding, just to make things seamless. The third document is called the healthcare proxy. This is also known as the medical power of attorney. And this particular document is going to name the person who would be responsible to make any sort of medical decisions in case of incapacitation. And don't just assume that your spouse has the authority to make that decision, because in some cases, hospitals and or providers might require this documentation. And without it, important decisions that involve your care can either be delayed or even contested. And I've seen this firsthand too. And it's not pretty. And the last document that would be part of any sort of package, and sometimes people include this, sometimes they don't. It's called a living will. Sometimes people will refer to as an advanced directive, but it spells out your wishes for end of life care, whether you pull the plug, don't pull the plug, if you're on feeding tubes or whatever. Just think the Terry Schiavo case from about 20 years ago, even Whitney Houston's daughter, I think it was like 10 or 15 years ago. There was a lot of, back and forth from that perspective. So no one ever wants to think about this. No one thinks that it can even happen to them. But if you're around long enough, like me, unfortunately, you start to see things happen to people along the way, even people who are in your age profile. So a lot of times people will sort of kick the can down the road and just think, hey, we'll put this stuff in place later. But if something like this were to happen, either you pass away or you're really sick and in a bad situation, this gives your family clarity, reduces chaos, takes all of that heavy emotional burden off the table, and even follows your specific wishes that you have versus someone else stepping in and deciding what happens. So at its core, and just to wrap this whole section up, estate planning, it is about who's going to get your stuff, I guess you could say, but it's also about just making sure the right people have control and can make decisions when you can't. It's also about protecting your family from any sort of legal chaos and just emotional uncertainty. And as you'll see here in a little bit, it's about making sure that if something does happen to you, that the assets can be transferred to the beneficiaries without any complications, without any specific delays. So by preparing up front, it can just save a ton of time, a ton of headache, and make sure that your family is in a good position moving forward. Okay, so now that we've set the table and we've discussed the basic estate planning documents that you want to have in place, you might be saying to yourself, well, hey, David, you're a financial advisor. Where does your role come into this? So our role is basically just helping facilitate everything and pull it all together. So again, you and your family, you're protected. There's a plan in place. And because of the fact that we might manage specific accounts for you and be able to see everything at a high level in terms of where you do have certain accounts, is making sure that all of those accounts are titled correctly with the appropriate beneficiaries so that they can go to the right people. I think what I see a lot of time is that most people, when they're setting up accounts, whether it's maybe even just a checking account, it could be an investment account, it could be their 401k, it could be when they buy a home. Most people I find are just typically in a rush to do that, and they're not even sure exactly who to name as beneficiaries or how they should set up a certain account, or maybe things have changed and they set up a bank account 10 years ago or an investment account 10 years ago and they named their brother or sister as a beneficiary and now they're married, but they haven't gone back to update it. So our role is really about connecting you with a good trust and estate attorney who's done good work for our clients, who can put those non-negotiable documents that we talked about in place, but also then to work with the attorney to understand what it is that we're trying to do. Look at all the accounts that you have set up, whether that's bank accounts, investment accounts, retirement accounts, life insurance policies, how a business is owned or the structure of a business, how your home is owned, and just making sure that all of that is in alignment with your estate plan. Also, things are going to come up along the way too. And you're going to have to revise your documents at some point in time. You might be in a situation where maybe you move to another state or someone passes away and you inherit money. So it's just making sure that all of those accounts are structured correctly in terms of, do you individually own it? Is it held jointly? And then who are the specific beneficiaries for that? And this is paramount, as you're going to see in the next section, when I start to go through how things actually flow to you and why having all of this in place is so important. So that way you can alleviate any sort of chaos down the road. So in summary, yes, we're not going to draft the documents like I was saying before, but we're going to help coordinate everything and keep on top of a specific client to make sure that they get it done. Because a lot of times what we see is we'll make the introduction to the attorney, they'll have the conversation, and then the client either might or might not get the appropriate information to the attorney, and then they sit on it and they don't do anything. And so what we do on our end, and we really take priority of this or look at it from an importance perspective, is try to drive it home and make sure that you get this piece of the planning put in place. Again, this is more foundational planning than anything else, but it's critical to just make sure that everything goes smoothly and that everything that you've worked very hard for ends up in the right place in a short period of time. So in this section, and I think I'm going to expand upon this in another video to just show you graphically what happens versus just reading off, hey, this is what you should do. But this is kind of the precursor to that. It's just showing you what happens if someone were to pass away with an estate plan and without an estate plan. So this is not going to get into specifics, but it's just going to show you exactly how things flow and where the potential pitfalls can be. Hopefully this part isn't too clunky. Whenever you're dealing with a slide, I always get a little bit worried, but let's go through it. Now, as I was mentioning before, so what happens when someone passes away with an estate plan and without? And let's go through it. Okay, so with an estate plan, again, everything starts with having a valid will and core documents in place. This basically sets the legal foundation and starts naming key decision makers in this whole process. So as part of creating your will, remember what we talked about, naming an executor is one of the main decisions that you're going to have to make. Again, this is going to be the person who is basically like the CEO of your estate. They're going to be the one who's going to be facilitating everything. And when you name someone, it avoids any sort of delays or confusion over who's in control. Now, for those of you who have young kids, you're going to want to obviously name guardians and give instructions for what's to happen. So what this does is it makes sure that your wishes are followed and that any sort of custody battles are basically kept at a minimum, if any. So this situation would occur if there was a death of both parents. I think that's the best way to think about it in this particular situation. Yes, it's a highly unlikely scenario to happen, but it does happen. And what if you're that person that it happens to? And so the next part, which in my opinion, I think is equally as important as having your estate planning documents in place, and that is making sure that your assets are titled properly. Hopefully I've driven that message home in the video, but just to visually illustrate it for you, hopefully will help. What you want to have happen here is that you want to have any sort of major accounts and even property that they're aligned with your estate plan and ultimately will bypass probate. So what this will do is make sure that your family has immediate access to any of the resources they need. Again, think checking account, think savings account, think brokerage account, retirement accounts, life insurance policies, anything that you can think of that has an ownership and or designation. And so what that will allow you to do is just have fewer delays and less financial stress on your loved ones. That way they can get immediate access to whatever it is that they need versus being locked up in probate, which could drag on for several months or maybe even a few years and cost a lot of money. The idea here is that with estate planning, you're going to have to go through probate no matter what, because basically when you're settling the estate, the executor is going to go to the court, they're going to present your will, and they're going to go through the validation of everything. So if we can have as many assets avoid probate and go directly to who they're supposed to go to, the quicker and the better. So let's just talk about probate real quickly. I know I sort of, or at least I feel I glossed over it a little bit. And this is why it's so important to have your assets titled correctly with the correct beneficiaries. The reason it's so important because it's directly tied to probate, if I haven't made that clear enough. And again, probate is a legal process where when someone dies, the court has to step in and really oversee the distribution of assets. The court's going to review your will, assuming you have one. And if you don't, it's going to default to whatever state you live in and what their division process is like in terms of dividing up assets. Probate also is public and it's very slow, and it comes with very high legal fees and often delays. Now, in some states, it can be relatively straightforward, but in many cases, it could take months or even a few years to settle everything, especially if there's going to be contested assets or minor children or real estate is involved. So again, the goal with any sort of good estate plan is to avoid probate entirely, because then when you can avoid it entirely, your wishes are followed smoothly and, of course, privately. The timeline to really go through the probate process and ultimately settle a estate could be anywhere from 1 to 3 months, which seems like a short period of time. It is a much shorter period of time if you don't have everything in order, like I'm going to show you in a minute. So if we go up here and we look at, well, what happens if you die without an estate plan? Again, there's going to be no clear instructions. There's no executor or guardian named, and the court's going to basically start from scratch. Probate can apply to, small estates in many states, even if there's, joint ownership and beneficiaries. Again, you're going to have to look at what your state uh, inheritance laws are if you were to die, what's called intestate. Again, when they step in or the court steps in, they're going to name an administrator or an executor. The family, there could be disagreements or even a fight about who should be in charge and who wants that, because you know how sticky sometimes that could be. And, in a situation where both parents aren't around, the court could name and even appoint guardians for minor children. And that might not align with, where your values and your wishes are. Big kicker is, and again, why having the estate planning documents in place, making sure that all of the accounts are properly structured, which I've probably been talking and mentioning several times throughout the video, is that way access to all of these assets aren't frozen, because basically the bank and investment accounts are locked until the court grants legal authority. So this is a huge one. Like I gave an example here, bills can go unpaid, surviving family may lack immediate funds, and that's what you want to avoid, because it could even go a step further where I'm mentioning here asset division. It follows the state law. Now in New York State, because that's where we are, if you're married, no kids, everything goes directly to your spouse. But if you're married and you have children, your spouse gets the first 50,000 plus the remainder, and then children will share the other half equally. So let's just use an example. Let's just say your estate has $1 million in it. The first 50K is going to go to your spouse plus $475,000 as well. So that's going to equal 525. And the remaining 475 is then going to go to any children, which would be split evenly if there was, say, 2 kids or 3 kids or whatever the case may be. So hopefully that helps, just seeing some basic math behind that. So we talked a lot about the higher legal fees and the delays and the public exposure. This whole process could take anywhere from 6 to 24 months on average. It could take a little bit longer. But again, when you zoom out and you look at everything that I've laid out here, do you want to go down the road of having clarity, or do you want to go down the road of having chaos and possibly backing your family into a corner where they might not be able to access accounts that can help them live their daily lives in such a vulnerable time? So what's riskier? That's, I think, the question that you have to ask. And that's why this important is really harped upon by a good financial advisor who can then bring in that estate planning attorney. So to wrap everything up, hopefully I illustrated just really how important this whole process is, just from an overall protection standpoint. That's why it's typically grouped in with part of the insurance conversation and sort of foundational planning conversation when we're dealing with clients that we work with. But if I haven't reiterated enough, it's really all about making sure that things are clear and there's a plan and you're reducing chaos. And that while we want to grow someone's wealth without a doubt, it's also about protecting that wealth and directing it, because you've worked pretty hard throughout your whole life to generate an estate plan that you want to make sure is going to the right people and can provide them with some relief in a time of ultimate distress. So I know it might not seem like a lot, and you're kind of like, hey, I'm 40 years old, I don't plan on passing away, or I'm 60 and I don't plan on passing away. This is just fundamental planning at its core. So with all of that being said, if you like this video, please hit the like button. It helps us tremendously grow. Unfortunately, you can't leave comments. We love you, compliance. Thanks for that. But if you have any questions, you can always email me, or you can book some time in my calendar if you want to talk things through a little bit further just to see and make sure that you're thinking about things the correct way. There's a Calendly link in the description below. Please also subscribe so that way you can stay in tune and in touch with any sort of future topics that we're going to be releasing, since it is the summer, because we're filming this in the beginning of July of 2025. Things will probably be a little bit quieter and we can really ramp up some of this educational talk and share with you the things that we're commonly hearing from clients. We'll see you in the next one.
If you're ready to take your financial planning to the next level with a customized approach, feel free to reach out to us. This way we can help determine if we can even help you or even point you in the right direction. The best way to reach out to us is through our website at sandersmith.com. Thanks for watching. For more valuable tips on financial planning, check out those videos here. And if you found this information helpful, please like and subscribe so you don't miss any future content.